cases that we've all seen where they just sit there on your dockets for years and there's no movement despite them being out of settlement conference typically. And so unfortunately many of them turn into either vacant properties or our clients are just desperate to move on with their lives and they have this foreclosure hanging over their head in one way or another. So we have three folks gratefully, who have blazed a bit of a path for us and have done some of these cases and are gracious enough to share their knowledge with the rest of the state. So Christopher Fasano, with MFY Legal Services, Jennifer Lerman from Staten Island Legal Services, and Derek Tarson with Legal Aid Society of Rockland County. Thank you, all three of you, for working together and bringing this presentation to us. And I hand it over to you, Chris.
Great, thank you. So just to give you an outline of the webinar, we're going to start with just a little bit of background and sort of the impetus for why we're giving this presentation today on this topic and why it's become an issue recently. Then Jennifer and I are going to talk about dismissals for want of prosecution under 3215C, and then Derek is going to talk about some of the other statutory tools. So these abandoned cases are, to a large extent, the product of the robo-signing scandal and its fallout. So after the scandal came to light, OCA implemented Administrative Order 54810, which simply required that the foreclosure law firms attest to the accuracy of their pleadings. It was later replaced by Administrative Order 43111. And the idea was that for newly commenced cases, the affirmation was supposed to be filed with the RJI. But rather than file the affirmation, plaintiff's counsel instead refused to file the RJI. And so as a consequence of this, cases became mired in the shadow docket. So the vast majority of cases, some 87%, spent some time in the shadow docket, and the delay wasn't negligible. On average, for cases filed between January 1, 2010 and September 30th, 2013, there was a more than 160-day delay between the filing service of process and the filing of the RJI. And this created a backlog with the foreclosure docket. So the certificate of merit requirement found in CPLR section 3012B largely fixed the problem for newer foreclosure filings. So starting August 30th, 2013, plaintiffs must include with the summons and complaint an attestation from their counsel that there's a reasonable basis for the action. And that's also attached to the summons and complaint the note, the mortgage, instruments of assignment, and all other instruments of indebtedness like modification agreements. So for cases filed after August 30th, 2013, there aren't deficiencies. But the cases that were filed before this date have contributed to the backlog. So the foreclosure docket still constitutes about 30% of all civil cases in New York as of last year, representing some 83,000 cases. And the delay in prosecuting these cases extends even after settlement conferences come to an end. So again, looking at the cases filed between January 1, 2010, September 30th, 2013, there was on average a 343-day delay between the last settlement conference and the entry of a judgment of foreclosure and sale in the upstate counties, so all the counties north of Rockland and Westchester. And in the downstate counties, that delay was 430 days. And this stage of the foreclosure process accounts for about 40% of the life of a typical foreclosure case. And in many of these cases, the reason for the delay is that the underlying papers are deficient in some manner. And there are still a host of cases filed by bond in which the plaintiff may not be able to obtain judgment of foreclosure, and after the case was transferred to a new law firm, that law firm simply neglected the case. And we're seeing increasingly that this issue of abandoned cases litigate with greater frequency. So in some ways, as the shadow docket fades, the abandoned cases rise. And looking at cases from, there's only one case from 2011, but it spiked to 13 in 2015. So it's important when assessing cases, the advocates identify this issue And what you're looking for are cases with old index numbers. And what you want to make note of is if one, the defendant answered to the date of last settlement, conference, and then the dates of post-settlement conference motions. So now I'm going to turn things over to talk more about the specific requirements under CPLR Section 3215C.
Thanks, Chris. So one of the tools at our disposal for seeking dismissal of abandoned cases is CPLR Section 3215C. Okay. So the language of CPLR Section 3215C states, if the plaintiff fails to take proceedings for the entry of judgment within 1 year after the default, the court shall not enter judgment, but shall dismiss the complaint as abandoned without costs upon its own initiative or on motion, unless sufficient cause is shown why the complaint should not be dismissed. A motion by the defendant under the subdivision does not constitute an appearance in the action. So there are several conditions that must be met for a dismissal under Section 3215C. So first, the defendant must have defaulted. It's important to note that defendant's motion to dismiss the complaint for want of prosecution constitute an appearance, so the defendant can subsequently move to dismiss for lack of personal jurisdiction. Plaintiff must have failed to take proceedings for judgment within 1 year. Dismissal under this section is mandatory, unless the plaintiff can show sufficient cause why the complaint should not be dismissed. Defendant can waive the default by serving an answer instead of moving to dismiss. And the dismissal can be sua sponte or by motion. So to go into more detail of the conditions, plaintiff must have failed to take proceedings for judgment within 1 year of the default. A recent Second Department case found that proceedings must only manifest an intent not to abandon the case. So what this means is that plaintiff does not have to actually obtain a default judgment within 1 year of the default. Plaintiff also does not have to seek the entry of the judgment within a year, of the default. Plaintiff must only take the preliminary step toward obtaining a default judgment. So for example, by seeking an order of reference. There is case law that holds that failed attempts to take proceedings are equivalent to abandonment. So in Portfolio Recovery Associates, where the plaintiff had made 2 attempts to obtain a default judgment against the defendant, these attempts both failed because of plaintiff's own errors or omissions. And as a result, the court found that plaintiff did not take proceedings pursuant to Section 3215C. So as I stated previously, dismissal is mandatory. Plaintiff can show sufficient cause why the complaint should not be dismissed. In order to show sufficient cause, plaintiff must both offer a reasonable excuse for the delay and demonstrate the merits of the action. Both prongs must be met. If a plaintiff can show only one, dismissal is still warranted. So the determination of what constitutes a reasonable excuse lies within the discretion of the court. Excuses were found to not be reasonable where they were unsubstantiated. Courts also take into account the length of the delay and whether the excuse predated the expiration of the 1 year period. So I have a few examples. In Madera versus Caprick, 54 AD 3D 827, where plaintiff did not move for leave to enter judgment against defendants until 3.5 years after their default. And plaintiff's excuses were that the plaintiff did not learn of its former attorney's failure to make the motion for leave to enter judgment until 1 year prior to the dismissal, and the attorney did not file because the attorney was incapacitated by a stroke. The second department found that the excuses were insufficient because they were supported solely by the affirmation of the current attorney and were not based on personal knowledge, and also because the former attorney's stroke happened after the 1 year period had expired, and because the excuse was vague, conclusory, and unsubstantiated. In Butendero versus Grinberg, 57 AD 3D 932, the second, where the plaintiff did not move for leave to enter default judgment within the 1 year period, the second department found that plaintiff's excuse, where plaintiff stated that its attorney had twice spoken to the doctor's office in a medical malpractice claim within the 1 year period,
and had been told that the complaint was being forwarded to the insurance carrier was insufficient because the allegations were unsubstantiated. Just one last example is Costello versus Riley, 36 AD 3D 581. In that case, plaintiff did not move for leave to enter default judgment until over 4 years after default. The court found that while it has discretion to excuse defaults resulting from law office failure, plaintiff's excuse in that case was rejected because of the length of the delay and because the excuse was unsubstantiated. Courts have found that excuses were reasonable where the plaintiff was able to show that it had entered into an agreement with the defendant or was reasonably relying on some sort of action from the defendant. So for example, in Rivera versus Schlagbaum, 204 AD 2D 524, the Second Department found that plaintiff's excuse was reasonable where plaintiff showed that its attorney had mailed letters and made calls to the defendant's insurer regarding when an answer would be filed, and the insurance adjuster kept asking for more time. So in that case, the plaintiff was giving more time to the defendant when it was requested. In another example is Urizo versus Madikov, 25 AD 3D 762. In that case, the Second Department found that delay was reasonable where plaintiffs presented evidence of the prolonged history of settlement discussions. One last example is Minago versus Girolando, 143 AD 2D 646. In that case, the court found that the plaintiff had not abandoned the case where the parties had entered into an agreement extending defendant's time to answer indefinitely. Okay, so now I'd like to turn to situations where the 1-year period for taking proceedings might be told. So one such situation would be where a defendant has filed for bankruptcy because a bankruptcy stays all non-bankruptcy proceedings. Another example might be foreclosure settlement conferences. This is because motions are held in abeyance during settlement conferences. This is also because of the nature of settlement conferences. So as we saw in one of the cases where the court found reasonable excuse for the delay, evidence of ongoing negotiations can demonstrate that the plaintiff has not abandoned the action. Of course, this would mean that the defendant has actually appeared in settlement conferences and there was some sort of negotiation. So lastly, I'd like to talk about the effect of a dismissal pursuant to 3215C. So generally, these dismissals are without prejudice. However, they can effectively be with prejudice where the statute of limitations has. This is because the dismissals for want of prosecution, and CPLR Section 205A would not apply. So the plaintiff would not get the additional 6-month period to commence a new action. So now I'd like to turn this over to Chris, who will be talking about other considerations and exceptions to 3215C motions.
Great. So the one sort of overarching theme to these cases is that the court is trying to ascertain whether the proceedings manifest an intent not to abandon the case, but to seek a judgment. And that inquiry is guided by the legislative intent behind 3215C, which is to prevent the plaintiffs from unreasonably delaying the determination of an action and to avoid inquests on stale claims. So, with that in mind, that kind of leaves us to sort of make sense of some of the case law, which is at times a little bit can be a little bit murky. So, one common example is the withdrawn motions, or what happens when a plaintiff moves for an order of reference and later withdraws the motion. So, in those circumstances, courts are likely to find that the plaintiff did not take proceedings for a default judgment. In the core case, the court reasoned that the effect of the withdrawal of a motion is to leave the record as it stood prior to its filing, as though it had not been made. But just note that in Dorstan, which is the Second Department case that Jennifer cited to earlier, they seem to entertain the excuse that the plaintiff needs to withdraw its motion in order to comply with the various administrative orders. And so the difference between core and Dorstan is that in the latter case, the plaintiff offered a reason for withdrawing the motion, however flimsy it may seem, which the court accepted. For delays after an order reference is granted, this is a much closer call. If the delays are expensive after the referee issues its report, it may evince an intent to abandon the case. So again, the statutory purpose of 3215C is to prevent plaintiff from taking advantage of defendant's default, where the plaintiff has also been guilty of inaction. But you want to tread lightly with this kind of claim. The Tavares case involved a delay of over 4 years from the date of default. And Dorston, which is the second department decision from 2015, states in a somewhat conclusory fashion that if the plaintiff moves for an order of reference within 1 year of defendant's default, then defendant has not abandoned a case. But the facts are pretty different between the two cases. And again, endorsed on the second department seems to have credited the plaintiff with trying to comply with the administrative orders. And there are also settlement conferences. And again, the delay was not as egregious as in Tavares. Vacated orders, that's much more straightforward. If the default judgment is later vacated, dismissal is not warranted. So if they're able to obtain the order of reference and judgment within 1 year and the judgment is vacated, that doesn't really manifest an intent to abandon the action. So now I just want to talk about some strategic considerations about when to make the motion. So more often than not, you'll find yourself in a defensive posture because the client is going to come to you only after they've been served with a motion for an order of reference, usually. And that's because where the plaintiff makes its motion more than 1 year after the default, it must provide notice of the application to the non-appearing defendants, and that's required under 3215G. But you can also move affirmatively to dismiss the case, and that a motion would not constitute an appearance. And you always want to consider pairing the motion to dismiss with a motion for leave to file late answer, particularly if the delay is short. If the court accepts plaintiff's excuse for its delay, it might be more inclined to accept the same excuse for defendant's delay in answering the complaint. And in the Lugo case, which is a first department decision, the court entertained plaintiff's excuse that it failed to prosecute the case because of ongoing settlement negotiations, then accepted the same excuse in granting the defendant leave to file late answer. And you always want to be aware of the statute of limitations. If the case is nearing the 6-year mark and the plaintiff has not attempted to take proceedings for a default, you may want to strategically wait to file your motion to dismiss. So this is where you get them past the 6-year period. And just some evidentiary considerations in attacking an application for a default judgment. So just remember that it must be supported by an affidavit made by the party and include proof of the facts constituting the claim, the default, and the amount due. So you should always ask if the affidavit is made by the party. So for example, if the affiant might fail to include a power of attorney demonstrating its authority from the plaintiff, and you should always ask if the plaintiff has personal knowledge of the facts, especially for these kinds of cases. They're likely to have been servicing rights are likely to have changed hands a number of times. So I think we're going to pause now to see if anyone has any questions about 3215C before Derek discusses 3216 and some other statutory tools.
So we have 2 things so far. The first one is Jennifer has agreed, thankfully, to share the cases that she went through at some great detail and the citations. So if you want that information, send me a quick email, or you can send it directly to Jennifer. We're going to post her and my emails in the which section here? I guess the chat section to everybody. So just keep an eye on that. Also, the one question we have so far is a broad question having to do with our cases in settlement conference. So what if the defendant initially defaulted, they didn't file their answer, but they were represented at settlement conferences, then those conferences end and nothing happens for years?
This is Derek. Go ahead if you want to go, Chris.
Yes, if they neglected to answer and settlement conferences, and then the conferences come to an end, as Jennifer discussed, the period of time that it was in settlement conference is not going to count against that 1 year period. So if they wait if they delay more than a year after the conference has come to an end, then you're going to have a pretty strong argument, bearing in mind that the plaintiff can come forward with a sufficient excuse. And so some of the ones that Jennifer cited to, which come up a lot in the foreclosure context, would be, if there are settlement negotiations after conferences come to an end. And another sort of wrinkle is, just bear in mind that under the regulation acts, so specifically 12 CFR 1024.41G, it says that, if a borrower submits a complete loss mitigation application more than 37 days before a foreclosure sale, a servicer shall not move for foreclosure judgment. So, if there is, even if there's no motion practice, if the borrower submits a complete application after the conferences come to an end, that also might be another circumstance in which it's told. But that's definitely the kind of case you want to evaluate for, for dismissals under 3215C.
I would just add something here, because one thing that I've run into in my practice is you bring these motions and then the plaintiff will say, oh, well, there was a litigation hold on, and that's why we didn't pursue it. And you should look carefully at these litigation holds. Usually the litigation holds are very short. Sometimes they were for Hurricane Sandy or for another reason. Also, sometimes litigation holds are imposed by Fannie Mae, but the mortgage is not held by, is not owned by Fannie Mae. So that's the kind of facts that you can use to respond to such an argument.
Essentially, it's the same analysis that Jennifer went through in some detail, regardless of what stage it is in that foreclosure process. When there's a stagnant, essentially a stagnant moment for a year in the courtroom, then that's really where you are looking to bring these cases.
Right.
Okay, and then we have, let's see, one more question now. Any recent or on-point case law on the failure to provide an affidavit by the party under 3215F?
I have some recent cases from Rockland County. I don't know whether there's anything in the appellate divisions, but I'm perfectly willing to share any orders that I've received.
Okay. And everybody's contact information, I may be lying about this, but I believe your contact information is at the end of the slides.
I don't think so, but we can certainly give them out.
Okay, so like I said, so I was lying, and if you have those issues or questions, you can feel free to email me, and again, I will put my email address in the chat box for everybody. Okay, so I think that's all we have for now, guys.
Okay. Yes. There we go. Okay. So I'm just wanted to discuss sometimes you're not in this position because your client has answered, and in my office we actually help our clients file pro se answers, and we've been doing this since 2010, so sometimes we have these answers from 2010 and nothing's happened. And unfortunately that means that 3215 is out because 3215 requires a default. But there are some other tools, unfortunately not as robust as 3215. The first one is dismissal for want of prosecution, which is 3216. And as the New York Court of Appeals says in this little quote, CPL 3216 is extremely forgiving of litigation delay. But it can be used once in a while. So the requirements for using 3216 are at least 1 year has elapsed since the answer has been filed, and that the defendant has served on the plaintiff a written demand to serve the note of issue within 90 days, and plaintiff has failed to serve and file that note of issue within 90 days. However, if the plaintiff does serve and file the note of issue within the 90 days, then that's deemed sufficient compliance, and the demand must be denied. Of course, in a foreclosure case, filing a note of issue isn't really going to do it isn't really going to do much good. There are very few foreclosure trials. Usually the only time that a note of issue is filed in a foreclosure case is if the judge requires it, and usually that has something to do with standards and goals. But to the extent that you want to use this, the written demand, and there is case law that states that if a written demand is deficient, that 3216 is not triggered. So these three statutory requirements are important. The demand must be sent by registered or certified mail. It must require the plaintiff to resume prosecution of the action and to serve a note of issue within 90 days of the receipt of the demand, not service, but of receipt. And that the demand must further state that the default in complying with the demand will serve as a basis for a motion by the defendant for dismissal to unreasonably neglecting to proceed. Now, it is possible, and this has happened in my practice, where the court will call status conferences in cases that are stagnant, and the court can make an order that substitutes for a written demand. So there are these two Second Department cases that state that where there's a certification order and warning that the complaint can be dismissed, that serves to trigger this statute. However, there is a New York Court of Appeals case, Catashon versus Fussell, where, and in this case, there was a stipulation between the parties that the plaintiff would file a note of issue. Plaintiff failed to do so, but the stipulation merely stated that the failure to do so would serve as a basis for the court to dismiss on its own motion. There was then a status conference, no party appeared, and the case was simply marked off without a written order, and the New York Court of Appeals said that does not trigger 3216. The trial court has to issue a separate order of dismissal. There are these fairly old appellate court cases which state where if there is if the note of issue has already been filed, or if a note of issue is not needed, that the 90-day notice is not necessary. These cases happen in the context where note of issue had already been filed, and then the case never moved on to trial. I'm a little concerned, even though these show up as having positive treatment on Lexis, I'm a little concerned about these cases because they are so old, and there are some recent rulings from the Court of Appeals construing 3216 strictly, such as Catashon. So just be careful, but they are out there. If the case is dismissed under 3216, the case can only be restored under CPLR 5015 for the for vacatur of any order. So the motion would have to vacate would have to be filed within 1 year of default, has to be a reasonable excuse, and a meritorious cause of action exists. However, there is this amendment to CPLR 205. It's a fairly recent amendment, 2008, stating that a new action may be commenced within 6 months, notwithstanding the statute of limitations, if the judge does not set forth on the record the specific conduct constituting the neglect. And just to give a little background on that, CPLR 205 allows for refiling of a complaint notwithstanding the statute of limitations within 6 months after the dismissal. One of the exceptions is usually if there has been a failure to prosecute, but that is waived if the judge does not set forth on the record the specific conduct constituting the neglect. The next statute to discuss is CPLR 3404, which is marking off a case on the calendar. And you've probably, many of you have dealt with a judge marking a case off the calendar. So you will probably be surprised to find, and I certainly was, that both the Second Department and the First Department have held that marking off a case does not apply when a case is not on the trial calendar, meaning that the case that it is pre-note of issue. I certainly have run into situations on my end, and many people probably have as well, where a case is marked off even if it's not on the trial calendar, but it's not supposed to be. The statute merely says that a case may be marked off or struck if it's unanswered on the clerk's calendar call, and if it's not restored within 1 year, then it shall be deemed abandoned and should be dismissed for failure to prosecute. The restoring a case under 3404 is very liberal, and unlike 3216 or 3215, it is not subject to the 1 year restriction of 5015. So within a year after the marking off, a case may simply be restored simply by the plaintiff requesting that it be restored. That's it. That's all that's necessary. It's only if it's after the year of marking off that there's a need to demonstrate a reasonable excuse, lack of prejudice, and a meritorious cause of action. And this is basically saying the same thing. After the year has elapsed, the plaintiff needs to show reasonable excuse, meritorious cause of action, and the lack of intent to abandon the action. There's no time limit after which cases dismissed pursuant to 3404 can be restored. And that leaves cases hanging in limbo, as Lopez, which is a Second Department decision, observed. Lopez, to the extent that there's a purge calendar needed by trial courts, and I've seen this happen as well, where a judge will call a whole lot of foreclosure cases on that haven't had any action, and if no one appears, then the case is purged from the calendar. Lopez recommended the use of Uniform Rule 20227, which we're about to talk about. 20227 states that where a plaintiff does not appear and the defendant or the counsel do appear, that it states every condition for one party not appearing or both parties not appearing, but the one that's most important for us is where the plaintiff does not appear and the defendant and or the counsel do appear. The judge may note the default on the record and dismiss the action, and may order a severance of the counterclaims or cross-claims. And if neither party appears, the judge may make such order as appears just. The objectives of this are to encourage efficient trial court control of the cases and to promote the disposition of cases within reasonable periods of time. The two cases where the Second Department wrote a fairly scholarly analysis of all of these statutes, of 3404 mark off and 20227. In Bassetti versus Knorr, the Second Department observed that it was not advocating that dismissals under 20227 should increase, but that a default should be treated consistently with what it is, a serious failure to recognize the importance of the orderly disposition of cases. This is a useful rule if a judge does call status conferences for foreclosure actions, and if plaintiff counsel fails to proceed or appear at one or more of the conferences. And like 3216 and 3215, an order of dismissal under 20227 can only be vacated under 5015A1, which means the motion to vacate has to be filed within 1 year of the default. And as this is a practice recommendation, if you have a calendar call at which the plaintiff fails to appear and the judge talks about marking the case off the calendar, it's worthwhile to suggest to the judge that you submit a proposed order to ensure that 20227 is cited rather than CPLR 3404, so that this case does not come back to haunt you. And if there were any questions here.
So we have one so far. So the question is a strategic question, really. So is it ever really worth it to try to get a case dismissed under 3404? It seems like a bit of a long shot.
You can always argue that if it's 3404 and if it really has been over a year since it's been marked off, and then you get a motion to restore 2 years later. The 3404 really is not a strategic tool that the attorney can use. It's really something that the court imposes, and then the attorney simply has to deal with it. But it is possible that you can argue that the plaintiff has not met the conditions for restoring the case because they evidence an intent to abandon, or they have not shown a reasonable excuse for the delay.
Okay. Can you talk? We don't have any questions at the moment, so for the moment, just for some talking points, I suppose. Can you guys talk specifically about some of the cases that you've seen and how it's played out? Some of the more specific facts?
Okay, I will talk about a case I had recently where the defendant had been in, the case was, I think, filed in 2009. There had been a delay because of the shadow docket before it even went into settlement conferences. It was in settlement conferences for quite a while, and there's quite a bit of discussion. But then the matter was released from settlement conferences, and 2.5 years went by. And then we received a motion for order of reference. And the court did recognize that the 2.5 years added to the time before the case had even been referred to settlement conferences did trigger 3215C. And in that case, we also had an argument that it had changed servicers, I think, more than once, and the affidavit of merit was from someone who claimed to be an employee of the attorney, in fact, of the new servicer, without really any evidence that it was a party or or any power of attorney giving them authority to proceed. And the judge noted that as well in dismissing the action.
Thank you.
I'm sorry.
Oh, go ahead. Go ahead. No, go ahead.
I was going to say in a couple of cases I've seen recently, one was where, I mean, sometimes when the plaintiff moves for an order of reference, they provide no excuse. So we assisted one homeowner who had filed for bankruptcy, so the period, the 1-year period was told, but there was extensive delay after the bankruptcy was discharged, and the plaintiff just could not account for, didn't even attempt to account for the delay after the bankruptcy was discharged. And then another case that we had was where a homeowner had participated in settlement conferences, then it was released, and the plaintiff waited several years to make a move for an order of reference, and they cited as a delay the fact of Hurricane Sandy, and then there was a transfer to that a new law firm had taken over. But again, even if you were to credit the plaintiff, for those delays, they still couldn't account for the entirety of the delay. So that's another sort of practice point. Just when you look through the plaintiff's papers, just note what periods the proffered excuses cover, and if they offer it. And you'll often see that the excuses that they offer still don't account for all of the delay.
Helpful. Okay, so there's one comment coming in from Jay Enwald, just noting that the Second Department recently heard oral argument in a case just last week with facts very similar to, I'm terrible with names, Dorasant, I believe the case name is, and seems to signal a lack of interest in dismissals under 3215, even though the plaintiff had attempted to withdraw a previous order of reference application. So just as an FYI. Another question here is, have any of you used RPAPL Article 15 as a defense to quiet title when the statute of limitations has expired?
That's a little that's not really on this topic, but I actually have not. I'm aware of it, but you really have to find, you really have to determine the statute of limitations issue first, and I think before you would use well, actually, I guess let me back that up. This would be brought affirmatively. I guess you can bring it affirmatively if you're pretty certain that the statute of limitations has expired and seek a discharge of mortgage. I have not done that myself.
Yeah, and we did have a statute of limitations training just last month, I believe it was, and that's probably where some of these questions can be answered. But I would say that, oh, I'm sorry, I'm just trying to read through some of these comments as well. And so they've used that as a counterclaim for statute of limitations. They use the statute of limitations as a counterclaim. Sorry, sometimes reading through these text messages get a bit complicated. We can talk a bit more, Maria, if you want to talk about this later. But I think that some of this was addressed in the statute of limitations training. If not, we can always go back to those trainers who have experienced this and worked through these cases firsthand and address it with them directly. Okay, so another question. It's related to what we're talking about, but it's outside of the scope a little bit of the legal obligations within the court proceedings, but rather what are the bank obligations when they do decide to abandon a case. So here's the question. If a bank starts a foreclosure action and then decides to charge off the loan and not pursue the foreclosure, what are the obligations to the borrower for the bank? For example, releasing the lien, notifying the borrower that the bank will no longer be responsible for taxes and insurance if they're escrowed. If you can just speak generally, it's not directly related to your topic, but it is tangentially related.
That's an interesting question. I actually, one of the problems with a loan being charged off is that charging off really only means that they are not actively pursuing collection themselves. But a charged off account could be referred to a collection agency. Charging off is really more for the lender's balance sheet. It simply means that they're recognizing it as a bad debt. I suppose that one of the, if it falls into one of these categories, you could bring a motion affirmatively. If a foreclosure action has started, you could bring a motion affirmatively under 3215C, or if the defendant had answered 3216. Claiming want of prosecution to get it dismissed. But I doubt very much that there's any way that you can have the court avoid the lien unless you deal with through bankruptcy court.
Right, so I would agree. So at the end of the day, what the bank decides to do with their accounting books, which, as you said, is precisely what they're doing when they charge off a debt. It doesn't mean that the debt goes away or that the lien goes away. It just simply means they have decided to not pursue it in the traditional form, and they can still sell that debt to somebody else who can do with it as they choose. But in terms of an obligation for them to alert the borrower that it's been released, there's no such obligation. There's no sort of a requirement to give them options to deal with that discharged or charged off debt. So unfortunately, it's sort of homeowners tend to be stuck between a rock and a hard place with those cases. If the case has already been filed in foreclosure, that's one thing. It can help. You can do something about the action, but the debt and the lien still remain. Unless, as you said, you go through the bankruptcy process, which is a separate process, which is not for everybody, but for many, it can be a useful tool. It's not a helpful answer, but perhaps it's at least practical for you. So let's see. Oh, here, another tool to keep in mind, relevant here, even if it's not dismissed, is CPLR 5001A authorizes the court to prohibit interest recovery if interest accrued due to the plaintiff's delay.
Yeah, that's a very good point. And I know that there was a pro se answer that was circulated recently on the listserv, which listed that defense as in the answer for the first time, and I think that's a very good argument to make.
Okay. Anybody else have any 2 cents or questions or anything that they would like to offer to the topic today, either chatting or verbally here with the presenters? All right. I know that the folks on the phone, I know that I've seen these cases, although I don't practice directly anymore, but I know that we still see them coming across our desks, most certainly in upstate. And it's great to hear some folks how they're approaching it. But there are options for these cases for your homeowners coming in the door. So if you have any direct questions about these cases that were listed, again, I put my email address in the chat box. Hopefully it actually got out to everybody and you can see it. If not, at this point, hopefully you can get to me in a relatively easy way. And then to my presenters, just thank you so much for putting this all together. Oh, and the CLE verification code, if you need credit or if you want to get a participation certificate, if you are a housing counselor, make sure that you email Michelle and we can get that set up for you as well. And just make sure you get your verification code. Michelle, anything else?
Yep, just the code that we put in the chat box is E as in Edward, 4. Just enter that in the verification code.
That was E. I don't think it came through. E as in Edward, 4390. Yeah. Okay. Thank you, everybody. Thank you for your time and your efforts, and it's much appreciated.
Thanks.